Hi friends, today's topic is the law of agency. Law of agency or the agency law deals with the relationship between an agent and a principal, wherein the agent has the legal right to act on behalf of the principal as his exclusive agent. The relationship between an employee and employer falls under this category. Agency agreement may be either express or implied. Apart from individuals, entities like a body corporate or a partnership can also enter into an agency agreement with any party. Under the agency agreement, the principal asks the agent to perform certain acts on his behalf and in his name, which may be assigning some work or some services or some specific kind of jobs which the agency performs on behalf of the principal in the name of principal. The agency as stated above, the agency can be express or implied. In the case of express agreement, the agreement should be in the form of a deed, not particularly in writing. And in the case of implied agreement, it need not be in writing. And in case of any dispute arises as to the relationship between an employee and a relationship between an agent and a principal, this relationship can be inferred from the relationship between the parties and also from the dealings or transactions. Under the agreement, the principal assigns some works like buying property, selling of some goods, or doing some special kind of work which the agent as the capacity of agents performs all the deeds and things and acts on behalf of the principal on the terms and the conditions agreed upon by the parties. For this kind of an agreement, the best example is the power of attorney, which assigns some deeds that have to be performed by the agent on behalf of the principal. All the acts, deeds and things performed by the agent on behalf of the principal will be construed as the acts, deeds and things performed by the principal himself. So much is for that the principal is held liable for all the cause and consequences arising out of the actions of the agent. In other words, the principal will be liable for all the acts and performance done by the agent as a principal. So the principal will be liable for the outcome of the actions or acts performed by the agent. Even if agent causes some injuries to a third party during the course of his business, in that case, the principal will be held liable for all such consequences, because the agent performs his duties under the clear instructions from the principal, and the agent's performance is totally based on the principal's directives. The duties in such a case, the principal will be liable to compensate for all the consequences or out of the actions of the principal, including financial interest or if any injury is caused in the way of emotion or physical nature, exactly in the nature of vicarious liabilities. The duties of the agent involves a duty to upkeep of the accounts of the monies received and spent by him on behalf of the principal, and to submit a report for the accounts to the principal from time to time, or as may be agreed upon between them, and a duty to carry out the instructions of the principal, and a duty to keep the confidential information of the principal, and a duty to carry out his duties with all due care, diligence and skill. In case any breach is committed by the agent, in that case, the principal has the right to sue the agent. That's all for the day. Thanks for watching.